The challenges to Act 10 were brought in both state and federal court more than a decade ago, and they focused primarily on the United States Constitution. They said that Act 10 either violated other state statutes, right? We all know that the open meetings laws were violated, and the Supreme Court of Wisconsin didn't deny that. They just said it didn't matter. There were also challenges that this violated various provisions of the US Constitution, and those challenges all ultimately failed. What had not happened until now was a case saying the Wisconsin Constitution has its own equal protection guarantee, and that guarantee is not the same as the equal protection guarantee in the 14th Amendment to the United States Constitution. And so the fact that the federal equal protection guarantee was not sufficient to invalidate Act 10 does not mean that the state constitutional guarantee is not offended by Act 10. We believe that Act 10, in many of its restrictions, violates the state constitution, and the court agreed with us.
What was the primary argument?
Act 10 sought to roll back tremendous amounts of the protection that public sector unions had won across time in Wisconsin. But the way it did it was not the same for all public workers. Act 10 claimed that it was dividing public employees into two different categories. There were public safety employees on the one hand, and there were general employees on the other. And public safety employees would continue to enjoy the labor laws that had existed in Wisconsin for many, many years, while general employees would face these tremendous rollbacks. But the legislature and then Governor Walker didn't actually draw a clean line that put public safety employees on one side and other employees on the other side. Instead, they drew a squiggly, jagged line that made sure that every public sector union that had endorsed Scott Walker's run for governor was categorized as a public safety union, whether the workers were engaged in public safety or not. And every public sector union that had not endorsed Scott Walker's bid for governor was categorized as a general employee union, even if those workers were engaged in public safety work. That is arbitrary and it's unfair and it's not treating like people alike, which is why this is a violation of the Equal Protection Clause.
Judge Frost is quoted as saying that the definition of public safety employee is what is unconstitutional. Can you explain that?
You might think that a definition of a public safety employee would talk about being a public employee who performs certain kinds of job functions and has certain kinds of responsibilities and authorities, and that anyone who doesn't meet all the parts of that definition would then not be a public safety employee. But that's not how the legislature did it. The legislature did it by picking and choosing specific unions and defining them as public safety unions. So, for example, vehicle inspectors who do not carry firearms, do not have the right to arrest people, they are public safety employees, according to Act 10. But conservation wardens, who serve an important law enforcement function in our parks and who do carry firearms and are empowered to arrest people, are not public safety workers, according to Act 10.
What happens now?
The ruling on Monday is not yet what we lawyers would call a final judgment. Judge Frost told us in July that he believed that Act 10 violated the Wisconsin Constitution in these ways. And he asked the parties to tell him which specific pieces of Act 10 needed to fall. Because remember, Act 10 was a big budget repair bill. There were lots of things in it. He said, I want to be careful and surgical about this. And so which specific pieces, based on the rationale that the court has laid out, need to no longer be enforced? And so the parties briefed those issues in the late summer. And what happened on Monday is Judge Frost said, okay, I've considered all the briefing, and these are the provisions that I believe cannot be enforced. He gave us a week to get him an order that reflects that. And when he enters that order, then there's a final judgment. Until the court enters a final judgment, the law hasn't really changed. Once there's a final order, then there can be appeals. Come Monday, we'll be filing our order with the court. Judge Frost will enter it. And once he does, I think we'll move on to the Court of Appeals and get a final answer on this at some point from the Wisconsin Supreme Court.
That was Jeff Mandell, President and Chief Counsel of Law Forward. This is Janine Ramsey reporting for Labor Radio.